What, you not going to let me walk around? No, that's okay. Good morning. Can you hear me okay? Are they alive and awake?
I hope so.
First, I'm very grateful to be here, and I want you to understand that I'm going to go through a lot of material very quickly, so I don't have a PowerPoint presentation. I hope you have a pen and a pad of paper, and if you don't, you're behind already. So jot down a few notes. You have a very good Department of Labor. I guess let me ask a quick question. What's the most important thing, the most valuable thing you have in local government? You got it, the people. The most valuable? If there was a prize, I'd have them give it to you. The most valuable, and if you treat them improperly, one of the most expensive, the people. And for our part at the Department of Labor, our mission is to make sure those people go to work, they have a good day at work, they're safe, and they go home to the people that they care about. And they get paid. That's what's important. We've got a Department of Labor staff, and I'll just give you a couple of quick anecdotes so that you understand where I'm coming from. We have a staff of about 87 or 88 people. About 65 of those people are all over the state of Indiana all the time, day and night, typically Monday through Friday, but if you have an incident on Saturday morning or Sunday morning, they'll be there. It may be a few hours take them to get there, but they'll be there. They're very dedicated to what they do. I kid a couple of our staff. We've got a couple of guys on our staff who, the other day we were talking, and I swear that they were on the safety committee for the presidential election. And I said, when Abraham Lincoln was elected president. We've got one gentleman who actually has been a safety professional and with the agency since before OSHA ever existed. We have another gentleman who used to be responsible for safety and security at the governor's residence, I think when Bob Orr was governor, I believe. So that's been a while. They're very good at what they do. They are professional. If they're not, we'll address that. Anyway, I'm grateful to be here. I'm going to run through a lot of material. I did see, if any of you have an opportunity to look, I believe the Indiana Constitution basically doesn't lay out many duties for the office of auditor. So I called over Johnson County, and after they finished laughing and hung up the phone, I looked on the internet and I realized that there were quite a few duties for the auditor. I won't go through that. You know what all those are. Honestly, it is one of the more important jobs in local government, and you all know that. So I'm going to get on with this, and what I'm going to address, first let me say, very simply, you have a very good Department of Labor in the state of Indiana. For those of you who are involved in workplace safety, the state of Indiana has the best workplace injury rate in the history of the OSHA program right now. The best ever. And I will say this very clearly, any workplace fatality is a bad thing. I get notice of every one of those on this phone, and every one of those hurts because that's somebody's family member that's not coming home. But the state of Indiana has the best workplace fatality rate in the history of the OSHA program right now. The state of Indiana has one of the three best elite safety programs, VPP and SHARP, in the nation. Texas and North Carolina are the other two, and we have a little friendly competition with them. The state of Indiana has by far, and I'll use a few acronyms, SGE stands for Special Government Employee. The state of Indiana has the best SGE program in the nation, period. And other states have called me and asked, how do you do that? And I smile and I say, it's just that simple Hoosier charm. And then I pause to see what the reaction will be. But you got a very good Department of Labor. The thing I want all of you to leave here today understanding is you are not doing your job alone. When it comes to OSHA, when it comes to workplace safety, when it comes to wage and hour, when it comes to child labor, literally all you got to do is pick up the phone and make a phone call and ask questions. Here in the state of Indiana, we have the OSHA operation, which is workplace safety enforcement, but then we have, when I was in private law practice, what I say is one of the best kept secrets in state government. We have InSafe, which is a group of safety professionals that have an equivalent or better level of knowledge to the OSHA safety professionals, but they are a free consultation service. If you have a question about OSHA standards, safety and health, you pick up the phone and call, and they'll help you. That's what they're there for. That's what they do all day long. So I'll give you a couple of phone numbers before I leave here, or as soon as I get them. Then we have a Bureau of Child Labor, so if any of you have community pools or you have kids mowing grass or things like that, any person under the age of 18 years, so literally up until that 18th birthday ticks over, they are potentially under the authority of the Indiana Bureau of Child Labor. If you have any questions about that, we have a very good director of the Indiana Bureau of Child Labor here in Indiana. He's very helpful with questions. Pick up the phone and call. Wage and hour typically deals with wage issues, wage questions. We have a wage claims process, which I hope none of you deal with, but if you do, it's pretty painless. Our wage claims process in Indiana handles about 1,700, approximately, give or take, 1,700 claims a year. And they have a success rate of about 97%. So that's very good. Anyway, let me get on with some of this. What I'm here to address is talking about people and the work and the workplace. And I actually have an outline that I started developing for clients when I was in private law practice. It worked pretty well. I developed it to help them, and I've carried it over into government and just kind of, it's evolved over time, and it works pretty well for me. I actually had one of my staff do a nice PowerPoint, did a nice PowerPoint presentation for me one year of all my outline. And I was doing a presentation, I forget who it was, and the first slide said Rick Ruble, Indiana Department of Labor, and it had the little clicker thing. I'm a little bit old school. I still believe in pencil and paper. Had the little clicker thing, and it said Rick Ruble, Indiana Department of Labor. So I give the whole presentation. I get done. A lot of it I had memorized, and I got done, and a lady raised her hand. She said, "Mr. Ruble, you never changed the slide." I went, "Oh, okay. Well, I'm Rick." So I went through the whole hour and a half and didn't even change the slide on the PowerPoint. And my staff said, "We're not sending you out with a PowerPoint anymore. We're just not." Anyway, I'll go through some of this stuff pretty quick. Oh, if you need to reach us, by the way, if you take something away from this, my name's Rick, and if you hate it terribly, tell them it was Bobby Knight and call the athletic department down at IU, I guess. Here's a phone number for you. Area code 317-234-3851. If I'm there, I answer the phone. If I'm not, leave a message. I'll call you back as soon as I get to the office. If you need child labor, wage and hour, InSafe, or any of those other folks, I'll get you to them. Pretty easy. And they are very helpful anytime you need them, usually, and I say day or night. If you call at 2 o'clock in the morning, it better be an emergency. But otherwise, they're very helpful, extremely helpful. Let's go through some of this stuff. And by the way, for those of you, when you get done here and you get back to your offices, please, if you will, take a few minutes and look at, the internet's a wonderful tool. We have the Indiana Department of Labor website. I had actually a brand new Commissioner of Labor, Secretary of Labor appointed by the governor in another state call me and say, "Mr. Ruble, I've looked at all the other states' websites. Indiana probably has the easiest to use Department of Labor website in the nation." I thought that was pretty remarkable. So whenever you get a chance, take a look at our Department of Labor website. It's there. It'll take you a few minutes. All the phone numbers, contact information, everything you need is there. If you don't find it there, call. We'll find it for you. Okay, let me start through this, and I'm going to go fairly quickly. So if you have questions, save those to the end. If you have complaints, save those until after I leave the building. You have people. One of your first questions is, are those people employees or are they independent contractors? Pretty simple question. The consequences of making the wrong choice can cost your county government thousands of dollars. I know because I've litigated a couple of those cases. There are some tests used by different organizations. So if you're dealing with the court system, the courts, restatements, you don't have to write all this down. Restatement second of agency, section 220. Former Indiana Supreme Court Justice Myra Selby wrote the opinion. If you're dealing with financial services, the IRS, which is the test that I would encourage most of you to use, it's called Revenue Ruling 8741. If you ever need it, you can find it on the internet, although it takes a little while because the newer folks at Revenue have been given kind of an abbreviated version of that. But the original Revenue Ruling 8741 is still the core basis of what they use. And it's 20 factors to evaluate, is this worker an employee or is this worker an independent contractor? The unemployment service area uses what's called, all across the nation, they use what's called the ABC test, except here in Indiana. Your legislators thought ABC were too many letters. So they truncated it to the AB, and then they forgot C. And that's true. And then if you're dealing with OSHA, strictly OSHA, they use a case that came out of the United States Supreme Court called the Darden, Nationwide Mutual Insurance versus Darden. I've got it at the office if you ever need it. But I would encourage you all, if you're looking at a worker and trying to determine whether they're an employee or a contractor, the IRS 20-factor test is a very good test, and it is pretty well recognized all across 50 states and U.S. territories. That's what our folks will look to, except in the OSHA context, and then they'll look to Darden. Okay, let me get rolling here. You deal with employees, EEOC, Equal Employment and Hiring, non-discrimination. And I'm going to run through some of this pretty quick. Pre-employment screening, so you've got potential new employees. What kind of screening can you do? Can you do it? And who pays for it? Does the county pay for it or does the employee pay for it? So I'm a potential new employee and I've got to go through some screening. Is the county going to pay for it or do I as the candidate pay for it? And please understand what I'm throwing out here is a lot of questions. Now, if you want the answers, call me at the office. That takes more time. I used to charge about $400 an hour for doing this. Anyway, drug screens. And I'm sad to say we have to do this, but drug screens. Pre-employment drug screens, periodic drug screens, random drug screens, post-accident drug screens, reasonable suspicion drug screens, and return-to-duty drug screens. When can you do them? When should you do them? And who pays for them? Those are all good questions. You may have to find answers to those. Our folks can help you find some answers to some of those. If you ever need it, on the internet, the United States Department of Labor, so the Federal Department of Labor, has an online drug-free workplace policy advisor, or at least they did have a few months ago. This is something I received a telephone call, it's been a couple years ago, from a very nice, very angry father about. When you're dealing with truck drivers primarily, although it could apply to a few other occupations, the United States Department of Transportation regulations may require an observed urine screen. That means somebody has to watch you pee in the cup. And a nice young lady had applied for a job and had to go through this. It's a matter of federal law. Her father called me, and he was very understandably angry about it. I would be too, but it was federal law. Okay, you're dealing with employees. You got somebody comes in for a job interview. For goodness sake, don't ask them their nationality or if they ever plan to be pregnant or if they plan to have children. You're just asking for a lawsuit. I mean, and if you call me and you've asked that, I don't have much sympathy for you. We actually had that happen here in Indiana. Now, I can't take credit for all of this. Part of this I stole from IU Hospital, I think. Anyway, so you have a workplace policy manual. I assume you do, and if you don't, you're behind the curve. Here are just some sample policies, and I'll highlight a few, and I'll jump past a bunch of them. EEO, Equal Employment Policy. By the way, that is different than affirmative action. And if you want to know the difference, look it up on the internet. If you can't find it, call me. Hiring procedures, compensation, classification, attendance, employee benefits, performance appraisal, termination and resignation, drug-free workplace policy, sexual harassment policy. I served on the sexual harassment task force 25 years ago, I think. Access to personnel records. This is something you've all got. Personnel files, right? So I'm your employee and I'm upset about something and I come in and I want my personnel file. Do I legally have a right to that file? No. That file belongs to the county. That can be very important in a disciplinary proceeding. In fact, if you need backup on that, no, that's not true. Sorry, I'm jumping to a later memo. That personnel file belongs to the employer. Now, as a matter of common courtesy, I always advise people, if you have an employee and they want to see their personnel file, their resume, their job application, their performance appraisal, that kind of stuff, it is a good courtesy to allow them to see that. But that file belongs to the employer, period. That is backed up by case law, the courts, all the way through the system. I don't know if any of you deal with trade secrets. I used to and litigated some. But if you deal with trade secrets, do you have a trade secrets policy? In other words, if I'm your employee and I deal with trade secrets, can I go home and tell my wife about your company trade secrets? No. You might want to consider that. Social media policy. It's a newer thing now. I still remember before we had cell phones. Social media policy. So your employees get on Twitter, Instagram, or whatever, and they want to complain about their county commissioners, county council, mayor, whatever. Can they do that? Can you discipline them for doing that? If you discipline them for doing that, are you going to get sued and wind up in court like this testifying? That's not a fun day. There's a May 30th, 2012 memo from the NLRB Office of General Counsel. He sent me a copy of it back then. Several government social media policies violate Section 8A1 of the National Labor Relations Act. I thought that was very interesting. So if you have employees on social media, consider that. If you have questions, call and ask. Your counties have vehicles. What's your policy on the employee use of the vehicle? Can I drive my county vehicle home? Can I take my wife to the grocery store? Can I take my kids to the football game? If I want to go to a, let's call them less than honorable place, can I take your county vehicle to my less than honorable place and park it out front so everybody can see that one of your county employees is at a place he shouldn't be? Cellular telephone use. We all have most people have cellular telephones now. This is something people don't think about. These are a little bit old. In 1999, a few years ago, a very high-ranking employee was making calls at work on the cell phone while he was driving. Hit and killed a motorist. Of course, there was a lawsuit. The employer wound up paying $500,000. 2001, another employee making sales calls while driving the car, struck another car and killed somebody. Went to jury trial. The jury awarded $21 million. That's a good chunk of money. 2007, employee driving and talking on the cell phone. That case didn't go to jury trial. They settled it for $5.2 million. Those are things to think about. You have employees and they're going to take leave. Do you have a leave policy? Vacation leave, sick leave, personal leave, family medical leave. And boy, if you get into family medical leave, good luck. I'll send you to somebody else to help explain that to you. Judicial leave. So you have an employee get summoned for jury duty. Can you let them off work to go to jury duty? Do you have to pay them while they're on jury duty? If you don't know, take a couple minutes and check, because eventually you're going to have employees summoned for jury duty. Unpaid leave, and this is something that I would advise any government official. Have your policies reviewed every year or two by a competent attorney. And I don't say that to spend your money. I say that honestly to cover your, how do we used to say, cover your backside. You're just doing your due diligence. You're just making sure things are covered. Have those policies reviewed every once in a while. If you have a county attorney, have them reviewed. And if your county attorney doesn't want to do that, now, I love what I do. If your county attorney doesn't want to do that, here's what I suggest. I suggest you wait till Sunday morning, and I'm told that it's helpful if you have maybe a glass of wine before you do this, and then you call your county attorney on their cell phone, because they'll be in church and their cell phone rings out loud in church, and they're not going to like that. Anyway, that's record keeping. You don't think a lot about record keeping. If you have questions, give us a call. Record keeping can be critical in defense of any allegations of discrimination in hiring, discipline, misconduct. So keeping good records, and that's simply pen and paper, however you keep records. If you do it on a computer, that's fine. Those records can be critical if you're challenged in an employment situation. There are 16 federal employment-related laws that have record-keeping requirements. Actually, I think I'm a little dated. There may be 17 now, but there are 16. So all of you know, you can go out and there's a company, they have employees in Mexico, their office is across the border in Texas, and they'll sell you a poster to cover all these, and it's pretty, like $400. Or you can get on the state of Indiana's website and you can get all the posters for free. It's up to you. And I say that's very true. The poster that you pay for is better looking. It truly is. It's a nice looking poster. I think they're $375, $400. The posters that you get from the state are all government approved posters, but they're all free. If you have personnel files, keep your personnel stuff, so your job application, your resume, that kind of thing. And now this is not law, this is, I guess, Rick's advice, because I've had to litigate that too. People tend to throw all the documents in a personnel file, so you've got Rick Ruble and everything about Rick Ruble's in that file. Bad decision. To me, I say, keep 2 sets of files. My job application, my resume, my performance appraisal, keep them in one file, because I can come in and look at them. Let's say there's some type of criminal investigation. A criminal investigator can come in and look at them. But there are some records that relate to an employee that are protected. So if you've got the I-9, FMLA records, HIPAA records, certain OSHA records, certain workers' comp disability records, they are protected to an extent by law. You don't want every Tom, Dick, and Harry in the county looking at those records. They don't have any business looking at them. I say keep 2 sets of files. Simple, fairly inexpensive. There's new OSHA record-keeping requirements. If you need to know those, look on our website. It's all there. Tons of information. Let's see. Now, let me get to some of the little more detailed stuff. So you have employees who work. And the question becomes, is that time compensable? Do they have to be paid for it? Seems like a pretty simple question. That question has resulted in hundreds of millions of dollars of litigation. The U.S. Department of Labor, our Indiana courts, federal courts have all looked to a standard they call suffer or permit to work. If you need to know the case law on that, check with your county attorney. If you can't get it, call me, I'll send it to you. Not case law from all over the nation, but the pertinent stuff from here in Indiana. If you have employees who are in training, a lot of times you have employees off in training. Must those employees be compensated for the time they spend in training? Good question. Sometimes the answer is yes. A lot of times the answer is yes. Once in a while the answer is no. You have employees who go for physical exams, drug screens, whatever. You send them down to the local clinic for a physical exam or drug screen. Does that employee have to be compensated when they go for that drug screen or physical exam? Good question. Could save you a lot of headache, could save you a lawsuit. And here's something that we run into more and more frequently. I'm technically paid for 37 and a half hours a week. I work about 55 or 60 hours a week. That doesn't bother me a bit. When I was in private law practice, I worked about 80 hours a week. So 55 or 60 is like having extra free time for me. But when you're in government, if I leave the workplace and I go home and I work on my government laptop for 3 hours, do I have to be paid for that 3 hours? To me, that's something you better get clear. Because if you don't, you have liability of a claim and a possible lawsuit. And I don't say that in a bad reason, I just say it because I've done it. I've been there. So when I came out of private practice back to the Department of Labor, that's one of the first things I got a handle on was, if you're scheduled to work 40 hours a week, you're going to work 40 hours a week. If you work anything over 40 hours a week, you had better have authorization from somebody, because if you don't, you ain't going to do it. And it just avoids a lot of hassle, and it avoids a lot of legal problems, difficulties. But those are things you want to get a handle on. When you get deep in the weeds in some of this, you will have, and I won't go into this, but in the federal case law, when you have employees on call, and I assume you may have maintenance personnel, all kinds of repair staff, who may be on call periodically. And the question becomes, are they engaged to wait, or are they waiting to be engaged? Nice phrases. Confuses the devil out of people. But there is a difference. For one, they must be paid. For the other, the law does not require them to be paid, but you can pay them if you choose to. If you ever have any questions about that, call and ask. Or call your county attorney. Just don't tell them I told you to call, because they'll call me and be mad. Rest periods and meal periods. We all work for a living. Every once in a while you need a little break. You got to go get a sip of water, go to the restroom, go have a sandwich for lunch, whatever. So when I take off, if I take off work for 20 minutes, 15 minutes, I go get me a drink, go to the restroom, come back. Do you have to pay me for that 15 minutes? Not a big deal one time. Add that up 5 days a week, 52 weeks a year for 20 years. Adds up to a lot of money. Must I be compensated for that time? And the general rule, if I'm away from my duty 20 minutes or less, leave me on the clock. If I'm away 30 minutes or more, and here's a critical factor, and relieved of any duties, so I don't have to answer the phone, I don't have to do what I normally do. 30 minutes or more, and I'm relieved of duty, you can take me off the clock. It's federal law. There's a little bit of wiggle room in there, but not a lot, and that's been that way for probably since the 1930s. But again, it comes back to, am I completely relieved of duty? Let's go on to a few other things. Employees work to get paid. That's why most of us work. Indiana has a wage payment law. I'm not going to go through all the nuances. If you have questions, call our staff. We'll be happy to go through it, send it to you. There was a question asked of me some time back of a local government official. They hadn't got the proper appropriations. Do we have to pay the employees? And to me, that's almost like asking, is the sun going to come up tomorrow? Absolutely, you have to pay them. If you don't pay them, somebody like me will sue you. And then you'll pay 3 times what you should have paid. Well, no. I'm a pretty nice guy. Somebody meaner than me will sue you. They're pretty nice guys, but they're going to get their money too. So absolutely they have to be paid. There's no excuse. When you have employees work and they earn pay, they must be paid by law within 10 days of the last day they worked. Now, there's a little wiggle room in that 10 days. We can talk about that later if you want to, one-on-one. But there is no acceptable excuse for not paying them. I'll give you the ultimate test. If you have an employee who dies, you're still obligated to pay that deceased employee. And if you got any questions about that, give me a call. I'll tell you how to do that and make sure it's all documented properly so you don't have any problem. But if you have an employee who works and they die and they're owed wages, you are obligated by law to pay that employee. And that's not taking sides, that's just telling you where the law stands. A lot of local government now has direct deposit, what we call direct deposit. The old days you used to go to work and you'd get a paycheck. And I talked to a nice older fellow, really nice gentleman. And his employer went to direct deposit, electronic funds transfer, EFT, whatever you want to call it. And this guy had worked in a factory for years, and it was pride to him. He got his paycheck and he brought that paycheck home to his family. It was their money to him, but he took pride in bringing that home. His company went to electronic funds transfer, and it nearly killed this fellow. Because now, when he got paid, it just went zip into the bank electronically. And he went home and didn't have anything. And to him, that was, it was like they took something away from his pride. But a lot of government uses electronic funds transfer. Even the state of Indiana uses electronic funds transfer. Indiana state law specifically authorizes direct deposit, or EFT, to a financial institution designated by the employee. So you don't get to choose which financial institution it goes to. I do. I didn't write the law, it's just there. There are a lot of other states that have modeled something close to that. There used to be an attorney out of Southern California who researched all 50 states and territories on wage payment, and I communicated with her once in a while on issues, but that particular law was modeled, not exactly, but closely by a lot of the other states. Can an employer pay by, have you ever seen the payroll debit cards? I mean, I'm a little old-fashioned. I still like getting cash or a paycheck. But a lot of employers use payroll debit cards now. And people go to the quick, I call them Quick John. What do they call them? Quick pay places. Can the employer do that? Good question. If you ever need to know, ask. If you have an employee, and this goes back to the nice gentleman I spoke to on the phone, he actually refused to participate. He had been at this place of employment for years. He was probably within 2 or 3 years of retiring. They went to electronic funds transfer. He refused to participate. The guy actually was mad and going to retire early. The attorney for the company called me. Nice, very nice young man. And I said, look, you've got a good employee. That employee's been an employee for 30 years or whatever. You are changing part of his world that he finds very important. As a company, why don't you advise your client to go to the local computer store and invest a few $100 in a computer and a printer and a little table and put it in the lunchroom where employees like that gentleman can go in on their lunch hour or after work or before work and print out their paycheck stub. Then they can take it home to their family. It shows their gross earnings, their net earnings, all their taxes, deductions, everything. Then they have something tangible in their hand that they can take home to their family. I talked to that attorney. About 3 weeks later, he called me back. He said, Mr. Ruble, I got a call and thank you. He said that was one of the smartest things my client ever did. He said they're just a big hero to all their employees because now the employees can go in there and print out their paycheck stub. They got electronic funds transfer, but they can go print out a paycheck stub. And I said, what'd it cost them? And he said, a few $100 for a computer and a printer and some paper. I said, it's well worth it. Well worth every penny of it. So those are things you can do to modify to fit the situation. In their case, it saved the employer a lot of money by going to electronic funds transfer, but the employees were unhappy because they no longer had that paycheck to take home. What the employer did was bought a computer, printer, little table, put it in the lunchroom, and they could print out their paychecks. So there's ways to work around that. This you shouldn't run into. If you do, look it up or call. Somebody makes a mistake on payroll. Employees overpaid. Can you deduct it? And the answer is yeah, within certain limitations. You got to give the employee 2 weeks notice by law, and you can't reduce that employee's income below a certain level. You can do that. If that ever comes up, call and ask. One of our staff or somebody will give you the details. And I'm going to start going through the rest of this stuff pretty quick. Garnishment. Can you garnish employees' wages? Of course you can. You know that. So if one of the local attorneys sends you some order to garnishment, are you obligated? Do you have to do that? Well, I don't know. You better check and find out who that attorney represents. But here's some common reasons. Bankruptcy, child support income withholding order, IRS tax levy, Indiana Department of Revenue levy, civil judgments, and in certain cases, student loan garnishment. If you have questions about that, there is a federal student aid website that will give you the details on how to handle garnishment for a student loan. Child support, bankruptcy, tax levy, and then there is a priority list for garnishment. That is on, I forget whose website that's on, but there is a priority list for garnishment. In what order and how far down the list can you go? Let's see here. Oh, and then, sorry, I had Consumer Credit Protection Act, see Title III. If you get that deep into it, you better talk to your county attorney. Let's see. Certain things you shouldn't do, and I say shouldn't. People do this stuff, and then I look at them and I go, are you just begging to be sued? You cannot fine, F-I-N-E. You cannot fine an employee, period. If you know of any exceptions to that, please let me know. You cannot blacklist an employee. That's Indiana state law. If you don't even know what that means, don't worry about it. There is a corporate employee lien law. If you got questions about that, call. Pregnancy Discrimination Act. If you got questions about that, call and I'll get you referred to the feds. This is something I got involved in at the local, state, and unfortunately federal level. Breastfeeding and lactation, when you have mothers who have children. And we had a gentleman here in the state of Indiana, very nice gentleman, had a family, had children, had built a great business, and his office setup was all glass. That's simply not an appropriate place for breastfeeding. His employees worked in a glass office. Everything was glass. The only thing that wasn't glass was the men's room and the ladies' room. And I went to one of the buildings here in town, and he made a very good point. He fully supported the activity. He was married and had children himself. But he had a problem in his place of business because what he was going to have to do was purchase a travel trailer and park it out on the parking lot. He didn't feel that was appropriate. So anyway, there is breastfeeding law, lactation law, and then there's lactation portions in the Patient Protection and Affordable Care Act. It's amended as Section 7 of the Fair Labor Standards Act. Here's something I ran into a few years ago. And any of you use biometric time clocks? No? Not a soul. Okay. Well, this was with a federal government organization, military contractor, fairly high security, and when the employees clock in, they had two different versions. You actually walk up and you put the palm of your hand on a screen, and that's how you clock in. The other version, you walk up and it reads the retinas in your eye, and that's how you clock in. I was amazed, new technology. But those are out there and available for whoever wants to pay the money to get them. There are, I know some defense contractors use them, but they're biometric time clocks. Polygraph Protection Act issues, if you get into that, better talk to a lawyer. Now, let's come a little bit back down to earth. If any of you have ever heard of whistleblower protection, there are currently 22 federal whistleblower protection laws. These are people who speak up about misconduct in government, and that happens more than you might imagine. Not always terribly bad, and it's not always criminal conduct. Sometimes it's mistake, oversight, simple stuff like that. 21 of those are administered by the United States Department of Labor. If it ever comes across any of that stuff, give me a call, give them a call. They have an office here in Indianapolis. They're very helpful. The guy who actually runs the whistleblower protection program in Indiana for the Federal Department of Labor used to work for me at the Indiana Department of Labor. Very knowledgeable fellow. There's one of those laws that our agency, the Indiana Department of Labor, administers. It's whistleblower protection for workplace safety. So if you have employees who file a workplace safety complaint, if there's an OSHA inspection, anything like that, and the employee suffers negative consequences, in other words, if you fire them, demote them, transfer them, reduce their pay, they can file a whistleblower claim. We'll investigate that. We don't have a lot of them, but we'll have maybe, 40 or 50 a year. Have a very good team. The gentleman who supervises that investigation is an attorney from here in Indianapolis, former law enforcement officer, so he's very, very skilled at that. The state of Indiana has a right to work law, and that won't mean a lot to a lot of you because it won't make any difference. To some of you, it will make a huge difference. If you got any questions, give me a call. That right to work law is posted on of course it's on the legislative website, but it's also posted on our Department of Labor website as a courtesy. So Indiana has a right to work law. You probably won't run across a problem, but if you do, call me and ask. And then I'll get to, if you have any interns, a good question to ask. Well, first, is the person under the age of 18, because then you implicate child labor law. If they're over the age of 18 and you have an intern, is it a paid internship or is it an unpaid internship? That nobody worried about that years ago. Until the economy took a downturn, and a lot of the big law firms in the nation, they used to have interns and they paid them. But when the economy took a downturn, they still needed interns, so they got interns, but they didn't pay them. Now wait, you got young people wanting to be lawyers, working in a law firm, and you're working them pretty hard on occasion, and you're not paying them. You're just begging for a lawsuit. And sure enough, there were multiple lawsuits. That all got sorted out by the Federal Department of Labor. So if you got questions, call us, or there is also, if you ever need it, And understand there's a difference. Indiana State Department of Labor, that's us. United States Department of Labor, that's the Federal Department of Labor. Both has very helpful information on their websites. I will say, if you call our Indiana Department of Labor, chances are you will hear, "Hello, Indiana Department of Labor," or somebody will call you back within a few hours. If you call the Federal Department of Labor, they are nice people, and you might get a call back in a few days. That's just the way life works. If you got questions, call and ask. Don't be afraid to do that. You have and I want to kind of summarize, and I'll not waste your time, by saying you have a very good Department of Labor here in the state of Indiana. You have people with a lot of experience in industrial safety, in every area of safety you can imagine. They have gone through things that I'm amazed. I just literally go home and sometimes I marvel at the things they deal with, all the way from military contractors to the Indiana State Fair stage collapse to the Feline Rescue Center. If you have questions, call. We will do our very best to help you. That's what we're here for. And again, you have OSHA enforcement, in-safe consultation, and in-safe consultation is literally a free service. If you've got questions, call them and ask. Wage and hour and child labor here in the state of Indiana. As far as the labor agency, they are all very experienced and very helpful. Pick up the phone and call if you need it. I want to thank you for your time. I'm not going to waste your time. I'm very grateful to be here. You all have a challenge. For those of you who know me, don't say anything bad about me. And if you need anything, call and ask. And when you get a chance, take a few minutes and look at our Indiana Department of Labor website. There's a ton of information there, and you'll probably find most of what you're looking for. If you don't find it, call us. Thank you very much for your hospitality.